All right, welcome everybody. My name is Sean Gary. I am a attorney here locally. I sit on the board for NABOR for 2024. I work on the forms committee. I've also worked on the forms committee related to the new forms that NABOR has promulgated as a result of the NAR settlement and the practice changes that we're required to implement. So I want to take a moment just briefly. I did this presentation on, I believe it was Monday. Yeah, Monday. So today is July 31st. As of midnight tonight, the compensation field in NABOR's MLS will be no longer available. And so the practice changes that we're going to be discussing are going into effect this evening. And as of August 1st, there'll no longer be a compensation field in the MLS. The focus of today's presentation, though, is going to be on the changes to our NABOR contracts and our NABOR forms. A lot of those pieces needed to be implemented and changes needed to be made as a part of the NAR settlement. As well, it also is a contract change year for our NABOR forms. Every 2 years, we update our contract forms. And so it just so happened this was one of those years. So most of the changes, 95% of the changes you're going to see here today in these forms are related to the NAR settlement. There will be a couple of small changes that you will see that are actually part of our normal updating to our contract. And it just so happens some of those changes are also going to be here in this form. So I'll do my best to try to highlight those pieces and we'll go from there. With respect to questions, I'm not going to be taking any live questions at the moment. We're going to try to get through these forms and we'll talk about maybe a manner in which some of those questions can be asked. We're certainly not going to be doing anything. I'm not sure. And if you have any, if you don't have the forms themselves, it looks like there's a website or there's an email address you can ask to get those forms, and they're in red line format as well. Real quick before I get started, I know there's been a lot of discussions about the NAR settlement. So I just want to highlight a couple of pages that are somewhat outside the scope of today's presentation, but are great resources for you as we navigate all these practice changes that are coming to NABOR, to the real estate industry. And so I just want to sort of highlight those. One of the most important websites that I think anybody can use during this time is the NAR Realtor, the Facts website. And on this, you'll see a number of different resources. The settlement FAQ is something that's very important to review. A lot of the questions people had on Monday and other times are really answered in that FAQ. It's a long document, I get it, but it's worth taking a look at. The other one is that Florida Realtors has a settlement page. And Joanna Watkins, as we all know, she's excellent. She's doing some presentations on buyer-broker agreements. Florida Realtors has released some of their forms, which are different than our forms, and it's obviously up to anybody's choice what they want to use in regards to that. The other piece, people were asking, where are the forms if you don't have them? If you go on NABOR's website and you go to NABOR contracts, once you log in, you'll see the new forms here. The forms themselves will be available through Form Simplicity and other vendors. They have been submitted to them. These are the 6 forms that we're going to be going over today. The amendment to buyer-broker agreement, the broker compensation agreement, the buyer-broker exclusive agreement, the listing of residential improved property, exclusive right and authority to sell, new construction broker services disclosure form, and a showing compensation agreement, no brokerage or agency. We anticipate, as indicated here, there will be additional forms that will come, maybe soon. Legal Resources has a meeting on Friday, and I know some forms are under discussion at that point in time. But these are the ones that we felt were necessary to get out to the membership for their use as soon as possible. And specifically, that's the listing agreement, because obviously listing agreements are going to be different, as well as everybody is now going to be required when they're touring a home to have a buyer-broker agreement. So with all that out of the way, let's get to the forms. Let's talk about it. And I just wanted to show everybody where these forms are in case they weren't sure. And I know you can also send an email asking for the forms and they'll send them over to you. But anticipate they'll be available in Form Simplicity shortly. Okay. The first form that we're going to look at today is the listing of residential improved property, exclusive right, and authority to sell contract. This is the standard listing agreement that NABOR has. However, there have been changes made to it as a result. And I've gotten this question before. People always ask me, well, do we have to use the NABOR forms? You don't have to use the NABOR forms. It's not a requirement. You can use the FAR forms. You can use the FARBOR forms. And you certainly need to speak to your brokerage. And you're going to hear me say that a lot, because a lot of this really relates to whatever your policies and procedures are of your brokerage. You will see that this listing agreement should look very similar on the first couple of pages as to what you're used to. You'll see here that most of these changes are really minimal on the first page. It really relates to just calling it a potential sales contract when it comes to the following items existing on the property that is being conveyed with it. And those changes don't have anything to do with the NAR settlement. I do want to highlight, since I've got you here, we'll try the highlighter aspect here. But one of the requested changes that we adopted this year was that the termination date shall be changed from, instead of 9 months, 270 days. It's going to go to 365 days from the commencement date if no termination date is inserted. So that is more of a substantive change. It does not relate to the settlement. But since we're going through the contract changes, I thought we should at least discuss it here today. So the termination date is automatically 1 year from the date of commencement. Okay. Once again, on the first page here, you're not going to see any changes. Those are highlighted in purple, not red. And there's an update to the date on the first page. So once again, no substantive changes to the first page of the listing contract from a settlement perspective. On the second page, you are going to start to see some changes. And one of the biggest changes that you're going to see related to this listing agreement, in addition to the compensation discussion, is that it's no longer going to be called a cooperating broker. As per NAR guidance and other guidance, it's now going to be considered a buyer's broker. So you'll no longer hear the phrase cooperating broker. It is a buyer's broker. And so that's the changes that you're looking at here on the second page of this document. And I'll just highlight one of them. You can see here where it's changed from cooperating broker to buyer's broker. So all the references now and all the forms going forward will no longer reference the words cooperating broker. You will hear the word buyer's broker, just for clarity's purposes with respect to the settlement agreement. So it's always going to be a buyer's broker if compensation is being offered. And that's an option that we're going to talk about. It's not a requirement, it's an option if the seller elects to offer compensation to a buyer's broker. Okay. Once again, this page, not a lot of changes to it from a settlement perspective and from a contract update perspective. Most of these, once again, you'll see here on like line 82, it's just calling it the buyer's broker, no longer the cooperating broker. The concept of cooperation still exists in the MLS and obviously in real estate, but it is not tied with respect to compensation. Okay. We're going to get onto the third page of the listing agreement, and this is where the greatest changes are. And you'll notice that so much of it is in red line form or purple form that I'm actually going to use the clean version of these forms after I go through briefly some of these changes. A couple of pieces I just want to point out to everybody. Under the settlement agreement, the seller is required to be offered a choice whether or not they are going to offer cooperating compensation or compensation to a buyer's broker. Our form needed to be updated to reflect that practice change. And so that is what you're seeing on this page as we get a little bit further down, is that there is the now option whether a seller wants to offer or not cooperating compensation. And those offers of compensation must be conspicuous, it must be in writing, and it must be in advance. The settlement agreement specifically requires that if a seller is going to offer compensation to a buyer's broker, that it must be in advance and put in writing. And as of course we all know, no offers of compensation will no longer be in the MLS. And the other piece that you see here on lines 124, 125 is the requirement that in all of our forms now, there must be a disclosure to the consumer or to the client, the compensation paid to a real estate broker and or broker commissions are not set by law and are fully negotiable. So I'm actually going to switch over to the clean version of the form because as you can see, lines 124 all the way down to lines 159 are really just essentially a red line. So I think it's more helpful as we discuss this new form to actually flip over into the clean version of it. So that's what I'm going to do right now. Okay, so this is the same lines that we were just looking at in the other form. It's page 3 of the listing, the new listing contract, lines 123 we're starting on. So broker compensation. I'm going to zoom out just a little bit with respect to it, just so everybody can see it. And hopefully everybody can still see it well, and hopefully you have it in front of you. Okay, so once again, lines 124, 125, disclosure, compensation paid to a real estate broker and or any broker commissions are not set by law and are fully negotiable. This is the required disclosure under the settlement that must go into all listing agreements as well as to any pre-contract disclosures. Okay. As a part of our updates to our forms, some of this was already in the work in terms of the structure here. But what you'll see is, and hopefully it's readable and understandable, but I am going to go through it in detail. Lines 126, seller shall pay total compensation, the compensation to the broker if a buyer who is ready, willing, and able to purchase the property is procured. And then there are options here about whatever agreement is negotiated between the brokerage and the seller with respect to whatever compensation should be paid to the listing broker. And this is the total compensation that'll be paid to the listing broker. It can be a percent and a dollar amount. It can be a fee, or it can be other, whatever arrangements those may be between your brokerage and the seller. That's where that would be reflected here within this. But you need to remember, this is total compensation. And this is a really important line that I want to point everybody to. And I'm going to read it and then I'm going to highlight it because there were some questions about this. So broker has explained to seller, line 131, that if the seller offers to compensate a buyer's broker who has procured the buyer broker compensation, such buyer broker compensation will be deducted from the compensation, with broker retaining the balance of the compensation to be paid by seller as set forth herein. And as you'll see, compensation is defined as the total compensation up here. So whatever numbers are placed here or whatever agreement is made, if compensation is offered to a buyer's broker, then that will be taken from this section right here. And this is really important because there were, like I said, there were some questions about this, but I want to be clear. This is a very important piece. This is actually just a clarification. In a lot of ways, this was sort of how the cooperating compensation was done, but not everybody understood that. So here in the listing agreement, you have total compensation, which is negotiated between the listing brokerage and the seller. And if this is an option, and we'll get to that option, it's below it, if the seller is willing to offer a buyer's broker compensation, that compensation will come from the total compensation listed above. And this is important because the settlement requires the seller to agree in writing in advance of any offer of compensation to a buyer's broker. Okay. All right. Next section talks about that buyer's agents and brokers, even if compensated by broker or seller, may represent the interest of a buyer. That's standard. That's always been there. Once again, we have a disclosure in number C here, line 136 and 137, that a buyer broker compensation is not set by law and is fully negotiable, and that the seller is not required to make an offer of compensation to buyer broker or other buyer representatives. So this is in compliance with the settlement, once again, advising the client or consumer that they're not required to make an offer of compensation to a buyer broker. They may, and that's what this next section is. The next section is line 138. The seller has the option to elect whether to offer buyer broker compensation. In other words, if they agree to do so, then you would need to fill in this box right here and check this box if that's what they're going to do. If they don't want to offer buyer broker compensation, then they would need to fill in box number 2. Importantly, if no box is checked, number 2 will be the one that is determined by default. If no selection is made, little I2 shall apply. That means the seller will not elect to offer compensation to a buyer's broker if no election is made in this section. So the default is that a seller is not offering buyer broker compensation. However, if they do offer and they do intend to, and that's a conversation that you, your brokerage, the seller need to have, then this is where that would be filled out. They would indicate here, and you would indicate as a part of this agreement, if they elect to share a portion of the compensation with the buyer's broker who has procured the buyer, and that upon receipt by broker of the compensation, broker shall pay to any such buyer's broker either a percent, a fee, or other. So once again, the compensation is the total compensation as defined up here in section number 1 that you're looking at right here. And this is the total compensation. And if a seller elects to offer compensation as part of your marketing discussion, as part of your discussions with that seller, this is where they would elect to do so. And these would be the amounts that the seller is electing to offer a buyer broker compensation. If they do not wish to offer buyer broker compensation, then this is the box that would be checked with respect to, which is also the default box. So that is the that is the amendments to the listing agreement that are really important for everybody to understand, because this is in compliance with the settlement agreement to make sure that it's clear to consumers and to customers that they have the option to offer compensation to a buyer's broker. It is not set by law and it is fully negotiable. So it's really important that when you're reviewing this with your sellers and you're talking about the changes in the industry, if they have questions, this is where those conversations are going to be had. And that is where the seller and your brokerage is going to have their own policies. Certainly your brokerage, you need to speak to your broker about what they will or won't be doing with respect to this. And so that is how the contract is going to be. The listing contract is reflecting those changes in the industry. So once again, total compensation for a listing broker. And if they want to share any portion of that, then this is where they would share it with a buyer's broker. And the seller needs to make the informed decision whether they do or do not want to do so. And that's the really important piece in this listing agreement. So hopefully that's really clear. The structure of this was actually in the works prior to the settlement agreement. We were trying to make it more clear about how the cooperating compensation was done under some of the old contract. And so this is just a way in which we think it can be displayed clearly to not only to the seller but also to the agent, so that they can understand how this is working. So, okay, I'm going to take all the highlighting off here. All right, so that is the change, and I'm going to flip back to the red lines real quick. And I hope I don't lose anybody switching between these forms, but I really want to make sure everybody can sort of see the changes that are made and where those important changes are made on our forms. And a lot of this too is going to be the discussions between you and your broker and the seller and how they want to proceed. Okay, I'm going to move on to the next sort of big change in the listing agreement. And there may be some questions. I think one of the questions we had was, transaction brokers, single agents, no brokerage relationships. Florida law continues to offer the various types of brokerage relationships. That's between you and your brokerage. And if you want to offer compensation with respect to those types of transactional relationships, and that's on line 160, you'll see here. I only bring that up because, like I said, there were some questions about this. And in this instance, if none are checked, then all of them will apply. That would be an offer of compensation to transaction brokers, single agents, as well as no brokerage relationship. But as you can see, nothing else changed with respect to the listing agreement in these sections here. The lines are still the same. Okay. The other big component of this, as part of the settlement agreement, is that there is now the option to offer, and there always was an option to offer concessions, but concessions are specifically allowed to be placed in the MLS if the MLS allows it. As of today is July 31st, 2024. Currently, NABOR, obviously the compensation is coming out of the MLS, and those fields will no longer be there as of today. And this could be changed in future MLS rules, so I want to be careful about that. But in the confidential remarks, you are allowed to indicate whether a seller is or is not willing to offer concessions. And that's as of today. And like I said, that rule may change at some point in time. But that's allowed under the settlement agreement, is that a seller is allowed to offer concessions, and that is allowed to be placed in the MLS. But speak to your broker about how they wish to proceed on that. Some people think, that's a marketing tool and can be used in various ways. But what I want to be super clear about, since I have a lot of people on the line right now, concessions and compensations are two very different concepts, And we typically, at least I'm an attorney, and I've done a number of closings here in Naples, and I can't tell you that I've ever heard the word concessions in any of my closings. Typically, the words are a credit towards closing costs and prepaids. So when we talk about concessions, conceptually, at least in our market, that has typically been a credit at closing to buyer for whatever it may be, for new carpet, for closing costs, whatever. That's what a concession is. A seller concession, as we define it here under the contract, is towards a buyer's closing costs and prepaids. It is not, and I want to repeat this, it is not compensation. It is not tied to compensation, and under the settlement agreement, it cannot be tied to compensation. It is a closing costs and prepaid. Now, as a result of the practice changes, and I hope I make this clear, a buyer may have to pay their buyer's broker at closing because the seller may not be offering compensation. One of the costs that a concession could be used towards is the payment of that buyer broker compensation, but it is not tied to that. And I want to be very clear about that. Concessions are closing costs and prepaids, and one of the closing costs for a buyer could be its broker commissions or compensation. So, since this is now explicitly allowed under the settlement agreement as something that could be placed into the MLS, and it's obviously an important piece, we've heard a lot of talk about it in the industry, we now have a specific place in the listing agreement, lines 172, 173, 174, and 175, where you can have that conversation with your seller about whether they do or do not want to offer concessions. Remember, everything's negotiable. So just because they may or may not say to here in the listing agreement doesn't mean that it could never be negotiated later, or however that works as part of any ultimate sale. But there is an opportunity here where you can speak to your seller about whether or not they wish to offer concessions to a buyer. And once again, under the settlement agreement, I want to be super clear. This is not tied to buyer broker compensation. it is tied toward the buyer's closing costs and prepaids. One of those could be a buyer broker compensation. So in the instance where a seller is not offering buyer broker compensation, they may elect to offer concessions. They may elect to offer both. They may elect to offer none and just leave everything as totally negotiable in the sales contract. That is totally up to a seller. That is totally up to the brokerage and their policies, and each individual brokerage and their whatever marketing strategies they employ. So the option is here. It is not a requirement. And like I said, I've got a lot of people, so I want to make sure we're very clear. Concessions is not compensation. Okay. So I'll go over these terms real quick since it's a new section. Seller concession. Seller is once again given the option whether they elect to offer concessions to a buyer or does not elect to offer concessions to a buyer. And there's a dollar amount or a percent of the purchase price and towards the buyer's closing costs and prepaids. And that is how it is defined as seller concessions. And it does authorize which amount may be used towards the payment of compensation to a buyer's broker. Doesn't mean that it has to be. It may be used towards that. And the default under the listing agreement, if no selection is made, then does not shall apply. Yeah, and like I said, some people ask, do you have to define what those numbers are ahead of time? A concession, it can always be negotiated. We all know. I mean, certainly, I worked all the time where either there's something that comes up in either during the transaction or as part of the closing process or as part of the sales contract negotiation, where they negotiate for X or Y towards closing costs. And that's the exact same thing here. It's just having that discussion with the seller ahead of time and placing it into the listing agreement. So those are the major changes in the listing agreement related to compensation, as well as adding the option for concessions with respect to it. Okay. I'm going to go through just a couple of other smaller changes in the listing agreement, and we'll see where we're at on that, see if there's anything. I am excited about this change. It's under actually line 177. It's not related to the settlement agreement. I want to be clear about that. But this is a change where the seller in the listing contract is required to provide accurate and current information for any association governing the property. I know we all chase our tails. I do. I'm sure a lot of you do chase our tails trying to locate that information, and we all want to make sure that we're having that conversation with the sellers at the time of the listing, so that we have all that for placement and providing to a buyer as part of the transaction. So it's now in the sales in the listing contract itself that they have to provide that information. Okay. Let's see here. Section 5 is the seller's sales contract obligation. This is just listing out what those obligations are, and you'll see here that if I'm going to do that. If the I want to highlight that if they elect to offer compensation, then they need to provide a verification of any buyer broker compensation. Just sort of a cleanup, a little change to the way that it's done. And then if they offer concessions, then they'll actually pay those concessions at closing. So just letting them know that that's their obligation to do so at closing. Okay. I'm going to just scan through the rest of this. I don't believe, oh yes, here's the other one with respect to the seller's obligation with respect to the current association property management contact info. At their expense, they'll obtain those. That's not the brokerage's expense. It's not the listing agent's expense. It's not the closing agent's expense. It's the seller's expense to gather all the current association and property management contact information, as well as application forms. Okay. Rest of this is just cleanup as far as the listing agreement. The other thing is that you'll see here, and I'm going to go to the end of the agreement. So there used to be the wire fraud was at the end of the listing agreement, and it's actually been moved up now, so it's above the signature line. So it's very clear that that it's there and that they've seen it when they signed this listing agreement. So that's really the change there, just moving that section around. So that is the listing agreement. Those are the changes to the listing agreement. And I want to point out to everybody, I think I was told the other day that these forms of NABOR's had its forms for 60, 70 years. We've updated our forms every 2 years. We've made them better every year, every 2 years, and we're going to continue to do so. These forms, as you see them here today, I'm sure there will be updates. I'm sure there will be things that need to be potentially changed or reviewed or tweaked as we go forward. But these are the forms that we think are the best way to comply with the settlement, to get our forms in compliance with the terms of the settlement agreement. And a lot of people have worked really hard on these forms over the past, I guess, almost 6 months, 5 months since March, since the settlement. So there's a lot of discussion. There's a lot that goes into each one of these forms. And everybody on the legal resources has worked really hard to try to get something to membership that is helpful and that is useful, and that is in compliance with the settlement agreement first and foremost. Okay. The next big form that we're going to talk about here today is the buyer-broker agreement, and this is an exclusive agreement. So under the terms of the settlement, prior to touring any home, which is a defined term under the NAR settlement, then you must have a buyer-broker agreement, which sets forth in writing whatever compensation is agreed to as part of your buyer-broker, as part of your buyer representation. There must be a specific and conspicuous disclosure of the amount of compensation in the buyer-broker agreement. It must be ascertainable. There must be no range. You are limited to the amounts in the agreement of the buyer-broker agreement. So if, for example, a seller was offering a greater buyer-broker compensation than you had in your buyer agreement, you are limited by your buyer-broker agreement. And obviously, we must continue to have any disclosures in there that commissions and compensations are fully negotiable. I want to just point out real quick, this is where things like the NAR settlement FAQ come into real help, because they actually have a definition in here of touring. Probably won't be able to find it as we go through here, but they have in here a whole definition about touring. What does it mean to tour? What exactly, when is that a requirement triggered? Does that count for virtual tours? They actually have all of those questions answered in this fact. Now, there may be some questions that people have that are not answered in this FAQ, but questions about when must I have a buyer-broker agreement in writing? Those are the types of questions that you will see here. And I'll just, like, for example, written buyer agreements, you'll see here on page 16 of the NAR settlement fact, it tells you exactly what must be in your written buyer agreements. And so if you have a question or your brokerage has a question about what must be in these buyer agreements, it's written out right here. And I would say too, each brokerage may have their own buyer-broker agreement, and that's, whatever agreements are made, that's fine, as long as they comply with the terms in the NAR settlement. Then that's fine. And here it is. So the question number 57 on the NAR fact is, what does it mean to tour a home? And they list it right here. Touring a home means when the buyer and or the MLS participant or other agent at the direction of the MLS participant working with the buyer enter the house. So that's what NAR sees touring to mean. This includes when the participant or other agent at the direction of the MLS participant working with the buyer enters the home to provide a live virtual tour to a buyer not physically present. So Those are the types of questions that I get a lot. I know a lot of people have questions about. And the only reason I'm going over this right now is this is not obviously an NAR settlement discussion, but it relates to when must I have a buyer broker agreement? The answer is when you tour a home. Well, what does tour mean? And that's the information right there. So NABOR has always had a buyer broker agreement. It's always been encouraged for buyer broker agreements to be used with buyers. Whether or not that was done, based on some of my teaching, it doesn't sound like everybody always used them, but now you're required to have them. You're required to have a buyer broker agreement, and it doesn't have to be this exclusive agreement. So long as it's a buyer broker agreement that complies with the terms of the settlement, that's sufficient. But essentially, it's going to let everybody know ahead of time what the compensation arrangement is going to be for that buyer and the brokerage. So this is the existing exclusive agreement. The Legal Resources is looking at other options with respect to these types of agreements as well. But we wanted to make sure we took our existing exclusive agreement. We wanted to make sure that was compliant with the terms of the settlement. And so that's what we have here today. And so this is the second form in your package, should be page number 8 in your package, and it's the buyer broker agreement. So you'll see here on the first page, talks about the broker is retained to assist buyer in acquiring an interest or right to use residential real property. One of the clarifications is that obviously the settlement only applies to residential real property, doesn't apply to commercial property as we sit here today. And these are the things that the broker will do for the buyer as outlined under section number 1. And one of the changes to this buyer broker agreement was to add the word tour, because that was a term of art that was used in the settlement agreement. And so we are using that phrase here as well, tour, to tie it, to make sure that it's clear to everybody that this needs to be done and that your touring properties are suitable to purchase. So section 1 is going to outline the rights and responsibilities of the brokerage under the term of this agreement. And I encourage you strongly to very carefully read what these are if you're going to enter into these agreements, because not only is it a compensation agreement, but it also lays out the rights and the responsibilities of both parties under this agreement. And so you have, if you enter into an agreement with a buyer, these are the functions you are agreeing to do. And I think it's really important for everybody to understand also that this is an exclusive agreement, and that may be different than some of the other buyer broker agreements, but this is an exclusive agreement. So this means when that buyer elects to work with you and they sign this agreement, you two are exclusive. You're not just dating, you're exclusive. And that means that the buyer cannot go out and find another agent. If they do and they sign another agreement with them, that buyer may be subject to 2 separate buyer broker agreements, which is certainly not a position anybody wants to be in. I mean, I have represented somebody who had signed one of these agreements, and then they went and purchased a home with a different agent while this agreement was still in place. And there was some real liability for that buyer because they had signed this buyer broker exclusive agreement. This is not a non-exclusive agreement. This is an exclusive agreement. And when they had done that, there was potential liability. And we'll talk about how that arises under this agreement. So the other thing too is on paragraph 2. It defines the brokerage relationship. And you would elect whether you're a transaction broker, a single agent, or no brokerage relationship. And obviously, in conjunction with this buyer broker agreement, you would provide the required disclosure of what type of agent you're serving in the transaction. NABOR has a transaction broker disclosure, which tells the consumer exactly what their roles and responsibilities are as a transaction broker. And so you want to provide that as well with respect to this. So you would make an election here about that. Under Florida law, everybody's presumed to be a transaction broker, so that is why it is a default as a transaction broker rather than a single agent, which has higher levels of fiduciary duties to a client than a transaction broker. It's very different under the law. So that goes beyond the scope of today's discussion, but it is important to understand who you are. And I know we offer classes on who are you in the transaction, and that's where these types of questions about transaction brokers, single agent, or no brokerage relationships are discussed in detail. Okay. So the buyer's role. So number 3 sets out what the buyer's role, and this is really important because the buyer agrees during the term of this agreement, and it says to work exclusively with broker. So during the term of this agreement, whatever term is negotiated below, the buyer will work exclusively with the broker, and to be available to evaluate and view properties, to refer to broker all inquiries in any form, any source regarding potential properties for sale or lease, provide reliable information, including financial information and necessary for the performance of this agreement, provide to broker general information regarding location, price, range, amenities, and other information. And all occasions, this is another important one, to notify other brokers or third parties of this agreement and broker's exclusive arrangement, broker's exclusive relationship with buyer. In other words, you have to let people know that you're already working with an agent under an exclusive agreement. So those are the requirements under this buyer-broker agreement, since it is exclusive with respect to that. Okay. Section number 4. A term of agreement. So under section 4, term of agreement, this is the length of the agreement. How long is this agreement going to be in place for? Is it going to be in place for 6 months, 2 weeks, 1 year, whatever it may be? That's what you would put into this section here. So you have your term of agreement, and that's going to be the commencement date. When does it start? And when does it finish? There's an automatic 180 calendar days from the commencement date if there's no termination date put in there. As well, people will often ask about this. There is an extension period. So let's say your agreement is set to expire at the end of the month. This is the same thing for listing agreements, but you're under contract. Then the agreement itself is automatically extended until the closing or termination of said contract. So if you're under a buyer-broker agreement, it's set to expire, you could either amend that agreement to include the contract timeframe, or per this phrase in here, for this language, the buyer-broker agreement will extend. Let's say your buyer-broker agreement was set to end at the end of August. They enter into a contract on August 25th, but the closing date isn't until November. Well, under this term in the contract, the buyer-broker agreement is going to extend all the way to the closing date in November. Or if they were to terminate it, though, if the contract terminated, then the agreement would terminate. So there is the sort of protection. They add this extension period on there. And then the other piece that's important as well for agents to understand is that if the after the termination date, so if the agreement ends at the end at August, you can insert a time frame in here where if they tour a home and then that you work with them, that you showed them, you toured a home, you work with them, and they then go and purchase that home during that time frame, then they're obligated to pay compensation to the brokerage during that time frame. So yeah, and so that's the sort of protection period. So if it ends in August, they can't just on September 1st turn around and go purchase that property with a different agent if the protection period was included in there without being owed compensation with respect to it. Okay, This is the other section. I'm going to flip over to the clean version, because now we get to the point where this section has been totally rewritten. And it's, I think, hard to read. I guess it's pink line. Pink line? It's very pink. So I'm going to go down on the clean version of this to the same line we were just looking at the buyer for the buyer-broker agreement. And hopefully that will be, it's much easier to read, in my opinion, in this section here. So section 5, that's what I'm looking at. So section 5 was over here on the red line. I'm going to move over to the clean version, so hopefully I don't lose anybody there. If you don't have a clean version in front of you, like I said, it's available on NABOR.com, where you can just look at the screen here in front of you. Okay. So once again, as we discussed, one of the requirements is that in each one of our agreements, we must now have the required disclosure. The compensation is not set by law and is fully negotiable. So that's where this was inserted into the buyer-broker agreement. And the broker, remember, this is for a buyer's broker, is very different than a listing brokerage compensation. The broker shall receive the following total compensation, the compensation for broker services as follows. And then it says for each property, and including personal property purchased by buyer, it can be a percent and $1, it can be a flat fee, or it can be other, whatever may be negotiated between the parties. That's where this would be included. Very straightforward. This is whatever agreement you and your buyer come to. Obviously, it's consistent with your brokerage policy that upon the essentially the successful purchase of a property under the terms of this agreement, then they shall pay these amounts. And that's pretty straightforward. The other piece that was also included in here is that if the buyer does end up doing some sort of renting, you can also put forth here what that renting may or may not be, what the fees may be with respect to that. And so you have that options here, because occasionally we know sometimes people change their mind, they no longer want to purchase and they rent, and then this will outline whatever the fees that'll be paid to you if you assist them with that as well. So broker compensation for a buyer, fully negotiable. And it's really important for me to point out, this is the total compensation. I want everybody to remember one of the key components to the settlement agreement, and one of the required practice changes, is that a buyer's broker is limited to what is written in this box here. Doesn't mean it can't be amended at some point in time, but the buyer broker is limited, regardless of whatever offer of compensation may or may not come from a seller on a listing. You are limited to these amounts that are here in this box. There is no, if the seller offers more than is listed here, that amount is not to be, it cannot be kept, it cannot be provided. It's not to go to the buyer's broker. And that's a very clear component of the settlement agreement. And so there's a lot of questions about, well, what if there is this sort of, I'll colloquially use the phrase overage. For example, if the seller is offering greater compensation than is listed here in the buyer broker compensation, what happens to this overage? Well, once again, everything is negotiable. Keep that in mind. You also have the option to amend your buyer broker agreement. And so there's a lot of options. But remember, amendments require both parties to sign to it as well. So some people, I just want to make that clear that whatever arrangements are going to be open and transparent to the buyer, and it needs to be very clear as to what's happening and how that's being negotiated. If there is, for example, additional compensation being offered by the seller, you're limited under this buyer broker agreement. So you and your brokerage are going to have a conversation about what that looks like, and obviously with your buyer and the negotiation that takes place. But you're limited to what's in this box for buyer broker compensation. One of the other options that people have talked about is you could potentially have with your same buyer, you could have multiple agreements. You could have, like I said, you can amend them. You can have multiple agreements, whatever that may be. That's part of the negotiation that everybody needs to figure out, and everybody has a different position and a different business model on those things. But I just think it's really important that everybody understands you're limited to this amount. Okay, I'll move on. I've made that point. Okay, this is, I'm going to tell you, this is one of the paragraphs that it needs to be well understood by everybody under the buyer-broker agreement. And this is essentially the conditions upon which the compensation is to be paid, how it's to be paid, where can it be paid from, and if there is no compensation being offered by the seller, well, what does that mean for the parties? So I'm going to go through this section very carefully, and you'll see, hopefully you'll understand why. Okay, so compensation shall be deemed to be earned on any property purchased, placed under contract, leased, or optioned by buyer, or by any person, entity, assignee, successor in interest, or nominee of the buyer acting on behalf of the buyer, irrespective of whether broker actually showed, located, introduced, or wrote an offer or contract with respect to any such property or properties under the terms of this agreement. That's a bit of a mouthful, but essentially, and this is once again relates to the exclusive portion of this agreement, compensation is deemed to be earned when the buyer purchases any real property during the term of this agreement, and limited. You'll see under here this agreement can be limited to certain counties. It could also be limited, maybe in other terms and conditions, to certain properties, but compensation is due to a brokerage if the buyer during the term of this agreement essentially purchases, or if he transfers it into LLC and then he purchases whatever it may be, compensation is due under this agreement. And that's part of the exclusive nature of this agreement. Okay. So when is compensation going to be paid? Compensation shall be fully payable upon the earlier of closing, buyer's right to occupy or control the property, or upon the event of the buyer's default and any contract to purchase or rent the property. So in other words, compensation is due by the buyer to the buyer's broker upon the earlier of closing, right to occupy, control, or upon the event of default. So if a buyer were to default, they may still be liable under this agreement to pay compensation to the buyer's broker. Now that's once again up to each brokerage and how they intend to enforce the provisions of these, but the option is there. So when is compensation due? Compensation is due essentially at the time of closing or these other sort of limited circumstances. So who's responsible to pay it? The buyer is responsible to pay for the compensation to be paid for the broker. So that makes sense. This is a buyer-broker agreement. Who's responsible to pay it? The buyer is responsible to pay it. However, and this is provided, however, a broker is authorized to negotiate for a seller, listing broker, landlord to pay all or a portion of the compensation. So in other words, the buyer is giving the authority to the buyer-broker to negotiate for all or a portion of the compensation that was outlined above to be paid to the buyer's broker. Okay. Buyer and broker acknowledge that a seller may offer credit at closing towards buyer closing costs and prepaid. So as we discussed and we saw in the listing agreement, we call these seller concessions. So they may offer credit at buyer towards closing costs. And buyer agrees that if seller's concession is provided, and there's two parts to this. So if a concession is provided and the seller and the listing broker is either not offering compensation to broker, or the compensation offered by the broker is less than the compensation due under this agreement, then the seller's concession will be used towards payment of the broker's compensation due under this agreement. So this is saying that if you have your buyer-broker agreement and the seller's offer of compensation is insufficient to pay the full amount under this buyer-broker agreement, but they are offering concessions, then the buyer-broker amounts will be paid from the seller concessions. It says will. It doesn't say may, it says will. Then the seller concessions will be used towards the payment of the broker's compensation under this agreement. Okay. And this is, I know I've talked about some, so these are all really important concepts that not only do buyers need to understand, agents need to understand, and brokers need to understand. If any amount paid by a seller listing broker to landlord and or seller's concession is less than the compensation due to broker under this agreement, the buyer shall pay the difference to broker upon the earlier of closing or the right to occupy, control, or default. In other words, the broker's compensation here is not dependent on whether or not the seller is offering compensation or concessions that are sufficient. The buyer has an independent obligation to pay broker compensation under this agreement. And if it's insufficient, then that buyer is still required to pay those amounts to the buyer's broker in this agreement. So that's an important piece. And it's really important that everybody understand the concept when it comes to these agreements. Can they be modified? Yes, of course they can. But a buyer's broker under a buyer-broker agreement, at least under this agreement, is independently required to pay for the services provided to them, irrespective of whether or not seller compensation is offered or concessions are offered that would equal the amount in this agreement. And I think that it's an important piece for everybody to understand. And then lastly, and we talked about this a couple of times, and I highlighted it above in the section, is that brokers shall not receive compensation for broker services for any source exceeding the compensation agreed to in this agreement, and shall disclose to buyer the amount of compensation, if any, paid by a seller, listing broker, and landlord to broker. So once again, you are limited to broker compensation as outlined in the terms of this buyer-broker agreement, limited. So that's a really important paragraph. I won't belabor the point. We've got a couple of other forms to go through. I do want to get through all those, but this paragraph here is really the one that everybody needs to understand as to how at least this buyer-broker exclusive agreement works. There are other buyer-broker agreements, brokerages offering buyer-broker agreements. Florida Realtors has a buyer-broker agreement they're offering. It's on their website. And I know we're at the legal resources under consideration for additional buyer-broker agreements that may be used if you have a client that isn't willing to sign an exclusive agreement, because this is an exclusive agreement. And if they buy any property during the term of this agreement, then they're going to owe compensation. And there's a business case for why not everybody would want to necessarily sign that, but that's up to your brokerage and however they want to proceed. Okay, I'm going to go through to the scope, because this was added in here. I think you can see on the red lines. Once again, you can see why I did the clean version here. It's just difficult to read. Yeah, so the scope is totally new. Wanted to make it clear that you could limit this to residential. Oh, I had to do the highlight. Is only applicable to residential real property located in the following counties. And that's going to be Collier, Lee, and Charlotte. That's typically, the area that our MLS covers. And so that's the default. But theoretically, if somebody entered into this agreement, if it didn't have any scope for counties, and then they went over to Miami, they could be subject to having to pay 2 commissions because they're under 2 agreements with respect to it. Okay. All right. 12 o'clock here. We've got another half hour to go, and then we'll see where we're at, how we can get through some of these forms. Yeah, in terms of changes, I'll go through just briefly some of the miscellaneous provisions. This was actually a discussion point. You'll see here under the miscellaneous, some of these were added. The buyer cannot assign this agreement. Under Florida law, all contracts are assignable unless you prohibit them from being assignable. Wanted to make sure that the buyer couldn't just assign it and try as a way to get out from underneath this. And the parties, if the parties want to amend this agreement, then they must do so in writing, signed by the buyer and the broker. Cannot be unilaterally amended by the parties. Yeah. So those are the important changes to the exclusive buyer-broker agreement. And obviously, everybody needs to have a buyer-broker agreement prior to touring a home under the NAR settlement. So please make sure you have that. That will be enforced by the MLS, similar to listing agreements at this point in time. I don't want to speak, for anything in the future, but at this point in time, it's not going to be collected, so to speak. But it will need to be available, and obviously whatever your brokerage policies are, they'll be the ones looking at whatever you're doing there. But it will be an MLS rule violation if you fail to have a buyer-broker agreement prior to touring a home. And so that's important to know, that everybody from an MLS perspective, that's how that will be enforced, at least from an association perspective. That has nothing to do with brokerages and how they they'll work through all that, but it is an MLS rule violation to not have that. One of the questions I did get asked a lot, since we're here on this topic, I just remember this question was, do you need to have a written agreement for open houses? And actually, once again, I want to refer back to the NAR settlement fact, and you'll see here, it says right here, if an MLS participant hosts an open house or provides access to a property on behalf of the seller only to an unrepresented buyer, will they be required to enter into a written agreement with those buyers touring the home? No. So in this case, since the MLS participant is only working for the seller and not the buyer, the MLS participant does not need to enter into a written agreement with the buyer. So I get that question a lot. Informally, formally, do you need to have a buyer-broker agreement for somebody that just comes to your open house? And according to the NAR facts, the answer is no, because you're there representing the seller, you're not representing the buyer. Now, if that person then says, well, I'm interested in this home and I want to go see some other homes, so of course, then you need to have that agreement in writing prior to touring any of those homes with respect to that. And once again, strongly recommend everybody. I know it's a lot, it's 27 pages, but I strongly recommend pulling the latest NAR settlement FAQ and just taking a look through it, because it will answer some questions, and it's really helpful about, well, wait, do I need this? Do I not need this? And until everybody gets really familiar and understands the rules, it's a great resource to have on hand. Okay. I'm doing a little better on time than I did on Monday, but so all right, amendment to buyer-broker agreement. So there is an amendment to this form. We just talked about this. There may be circumstances where various terms of that agreement, whether it's an extension of the agreement, whether it's compensation, or whether it's related to scope of the agreement in terms of counties or whatever it may be, may need to be amended. And so there is an amendment to this, and it's an open amendment, and the terms that can be amended here. Once again, remind you, it requires the buyer's signature, cannot just be unilaterally amended. And if in some ways there was negotiated something in the contract, you would also still need to amend your buyer-broker agreement. For example, a sales contract is not going to amend the terms of your buyer-broker agreement. They are not parties. Brokerages are not parties to sales contracts. Only the seller and the buyer are parties to those sales contracts. So if you have a change to your buyer-broker agreement, you need to make sure that you're doing an amendment to your buyer-broker agreement if you have one of those scenarios that we talked about. So that is there. It's a blank form, just like any of the other blank amendments that you can use. Okay. I'm actually going to, I'm going to skip over this form, which is the showing compensation agreement for sale, no brokerage or agency relationship. And it's not because it's not a form that isn't important, but I want to go through the other form first, and then I want to come back to this. This is essentially a circumstance where the seller has no brokerage relationship to a buyer's broker. This is most likely going to be in your for sale by owner circumstance where they're going to offer compensation to a buyer's broker. And this is the manner that it will be. We're recommending this form at this time to be compliant with the settlement agreement. We took the old showing compensation agreement and then amended it so that it could be used under the settlement terms. So we'll come back to this form. We'll have time to come back to it, but I want to go through the next form in detail because this is a totally new form and it really relates to the other form in some way. So under the old MLS rules prior to the settlement, compensation was obviously available as part of the MLS. And one of the important roles of that compensation piece in the MLS was that it was essentially an agreement between brokerages as to how that would be paid at closing. And since it's no longer going to be in the MLS, we have a new form called the broker compensation agreement, which will reflect whatever agreement is between the listing broker and the buyer's broker with respect to any offer of compensation. Because remember, it cannot be made on the MLS anymore. And I got one question somebody asked me, they said, well, can I upload this form to the MLS? The answer is a big no. You cannot upload forms. You cannot put anything with respect to compensation or commissions in the MLS post midnight tonight, July 31st, August 1. You can no longer have anything related to compensation in the MLS post tonight. And so, but this form is an agreement between the listing broker and the buyer's broker for a specific property, for a specific buyer, what, if any, compensation is being offered to the buyer's broker. Once again, you'll hear the term buyer's broker. It's no longer cooperating compensation. So conceptually, some people may have not heard the term, or they may be thinking, cooperating compensation, but this is a buyer's broker is offering, this is how you memorialize that offer of compensation if the seller elected to it, if the seller elects in the listing agreement to offer compensation to a buyer's broker. Well, how do we indicate what that is? And there's been a lot of talk about, well, how do we know what the compensation is? Each brokerage will have their own policies. A lot of people have said, well, you'll call the agent up and they'll tell you what it is. But then, of course, you need a way to memorialize legally, well, what is the compensation being owed? Just because somebody sent a text message back, that may not be the best way to memorialize what that offer of compensation is. And so this form is the memorialization of any offer of compensation between a listing broker and a buyer's broker. And I just want to point out one other thing, is that a listing broker cannot unilaterally make an offer of compensation to a buyer's broker without the seller's prior written consent. So as part of that listing agreement, that's why it's very important that the seller, prior to any offer of compensation be made to a buyer's broker, has to, in writing, in advance, do so. That does not mean, of course, that a buyer couldn't send over an offer requesting compensation, and then obviously the listing broker and the seller would have to have that conversation. But a listing broker cannot unilaterally offer compensation without the agreement in advance by the seller. And so if they have elected in advance to offer compensation to a buyer's broker, this is a form that could be used to memorialize that agreement. Your brokerage may have a different form, but this is a form that a lot of people think is, it's important because we need to be able to memorialize that. So here, I'm going to go through this form in detail. Okay. So we have your listing broker is a party to this contract, and your buyer's broker is a party to this contract. The seller and the buyer are not a party to this contract. The listing broker and the buyer's broker are a party to this contract. And it relates to the following real property. So you'll see here, this is where the address of the property would be entered into. And the name of the buyer would be indicated here. So you have a buyer, we are offering compensation with respect to this property or this buyer. It is not a blanket offer of compensation to any buyer. This is with respect to a specific buyer. And you'll see here, it's a one-page form. It's pretty straightforward, but let's make sure we're all on the same page. So the listing broker has entered into a listing contract with the seller of the property in order for listing broker to provide brokerage of service to buyer, whereby seller has agreed to allow listing broker to provide compensation to a buyer's broker for a procuring buyer. Once again, the seller in writing in advance has agreed to provide compensation to a buyer's broker. And then listing broker agrees to pay to the buyer's broker. The seller is not agreeing. The listing broker, the seller has agreed in writing in advance in their listing that a portion of the total compensation may be paid to a buyer's broker. And this is the amount that the listing agent will agree to pay with respect to that buyer broker compensation under two circumstances. So there's two circumstances. Provided the sale transaction closes with the buyer during the term of the listing agreement contract. In other words, if the listing expires and, well, they're not obligated to pay that. And the buyer's broker is the procuring cause of the sale on the property to the buyer. So once again, the concept of procuring cause is still there, and it will be handled under the applicable professional responsibilities, ethics, and arbitration. You'll see that later. So the listing broker is offering to pay buyer broker compensation, which was previously authorized by a seller, in a percent and a dollar amount, in a fee, or any other amount, whatever was agreed to ahead of time, provided the sale closes with this buyer during the term of the listing agreement, and the buyer's broker is the procuring cause. So those are the circumstances which the compensation will be due. Okay. And once again, making clear that the compensation due to buyer's broker under the terms of this agreement will be paid by the listing broker at closing. So a portion of the total compensation, as we looked at in the listing agreement, a portion of that will go, if elected and agreed to by the parties, to the buyer's broker. And that'll be paid from the listing broker. And this is really important. This agreement is part of the arbitration procedures in the National Association of Realtors. And so just like you had in the past, where there may have been any commission disputes between the parties, and it would be submitted to arbitration, and it would be subject to the requirements under arbitration, whether it's procuring cause or any of the other myriad of circumstances that may occur with respect to this type of buyer broker compensation being paid by a listing broker. It's still going to be handled in the same manner as it was before. So I'm certainly going to recommend that obviously everybody make sure that everybody's on the same page about what compensation is going to be paid, because that is no longer going to be displayed in the MLS. It's obviously no longer going to be through the MLS process. You need to have a separate and independent way to verify and enforce that offer of compensation that is being made by the listing broker to the buyer's broker. And this document will reflect, from a legal perspective, that offer of compensation, and it will be handled in the same manner that the types of sort of commission arbitration disputes were handled before. And I think hopefully not too many people are familiar with that process, but if you are, I'm sure a lot of brokers are. And that's the way it's still going to be handled moving forward. Okay, I'm going to go over the other form here, which is the showing commission compensation agreement for sale. I think it's probably easier for me to just show that one in clean format. This once again is the form, and I want to be clear because occasionally I do see people, maybe put it in. This is where there is no brokerage or agency relationship. And this is different because in the other form that we just looked at, remember, it was between a listing broker and a buyer's broker. Here, this is between a seller and a broker. So this is where a seller who has no relationship with the broker is offering to pay a compensation amount, which is set forth here. Once again, you have the required disclosures, not set by law, fully negotiable. Notwithstanding, the buyer, if a broker procures a buyer who is ready, willing, and able to purchase, with whom seller enters any contract, they'll offer to pay these amounts, which are similar in terms of the options, whether it's percent and a dollar amount or a fee or any other type of negotiation between the parties could occur there. And so this is the form that would be used if you have a for sale by owner. And it's important to point out that this is between a seller and a broker. This is not a listing agreement. This is if a seller is willing to offer compensation where they don't have a listing agent or a brokerage, and they want to do so to a buyer broker. This is how that would be accomplished. Yeah. Okay. Talked about the broker comp. Oh, okay. And the last form that's in our packet here is the new construction broker services disclosure form. And I just want to be clear about this form. This is not a buyer broker agreement. This is the disclosure form that we have always had with related to new construction. And this is simply outlining the terms and conditions. Outlining the disclosures and the following services that a broker may offer with respect to new construction. But this is not a buyer broker agreement related to new construction. You would need to have a separate buyer broker agreement. This is simply an update to the buyer broker agreement with respect to the settlement agreement, making sure that it's compliant with respect to it. And so taking out any references to that they will be paid, or just and adding the required disclosures. The compensation is negotiable. So some people use this form when they are working on new construction with a buyer. They want to make clear that they're not responsible for, floor plans or whatever it may be, and that they're not ultimately responsible. So this is just an update to the new construction form with respect to it. There's one other thing on the buyer. I just remembered on the buyer broker agreement I wanted to just talk about briefly. I don't mean to jump around on you guys, but just since I just thought about this, and this is an important piece as well. I just want to talk on the buyer broker agreement briefly about the fair housing, equal opportunity piece. So under the settlement agreement, there were concepts that, you are not allowed, you were never allowed, and you're specifically not allowed under the settlement agreement to filter homes by whether or not they offer compensation. So your ethical obligations as well as legal obligations of the settlement are to show homes irrespective of whether or not the seller is offering compensation. And so that obviously continues to be the case. I want to be very clear, and you'll see in the NAR settlement facts that that is something that you cannot do, and there'll be no way to, the MLS certainly will no longer have compensation in it. But the other piece is that in here, we talked about the concept of concessions. And so it says here, broker will show properties regardless of any seller concession being offered in connection thereof. However, there may be circumstances where a buyer does not want to see any properties that does not have seller concessions for closing costs and prepaids, and they can elect or decline to show properties where concessions, where no concessions are being offered. But that's very different than compensations. I want to be super clear on that, that everybody is obligated and continues to be obligated to show properties to their clients, irrespective of compensation, because everybody's going to have their own buyer broker agreement now. They're going to have their own buyer broker agreement that sets forth what they're going to be paid on this. Now, you may have clients that have direct you to do certain things, but you're still required to show them properties or to offer properties, even if no compensation is to be paid. However, in the buyer broker agreement here, you can elect, well, that buyer can elect whether they do or don't want to see properties where no concessions are being offered in connection with the sale thereof. So that substantively covers, from my perspective, the major changes to our agreements. And I'm sure there's going to be a lot of questions. And I know, since we weren't directly taking questions here today, we will do our best to try to answer those questions and to respond. And there may be circumstances where, and I will just tell you, I mean, we reviewed these forms with brokerages and other people and have spent many, many hours debating them. But there may still be circumstances that people say, what about this? What about that? Did you think about this? And hopefully we did. And there is a really good reason why it may be different, or maybe how we think it should be handled under the terms of the settlement agreement. But please do provide feedback on these forms. As I've indicated, these are forms that are always updated at NABOR. And we always need to respond to new laws, whether they come through the Florida legislature and or they come from practice changes or settlement agreements, whatever they may be. We do our best at the Legal Resources and at NABOR to try to respond to members' needs and members' wishes as best as we can. There may be really good reasons, legally or otherwise, why not everything can be accommodated. But we do want to listen to that feedback. We do want to hear what this looks like. If there's needs for other types of forms or whatever they may be, then certainly provide that feedback. I think I saw in the chat, looked like we were going to take, I think, with respect to today's webinar, and if you want to ask questions, then you can provide them, and we'll do our best on Legal Resources to get back to you on those questions. Like I said, I know a lot of people will have questions. Some of those can be answered by your brokerage. Some of those can be answered by the NAR Settlement Fact, which once again, I'll highlight. I think it's great because they have been taking a lot of these questions over time, and they're constantly updating. As you'll see, this one, for example, was updated on July 15th. There was just a recent update on July 23rd. And if there are changes, then at the Legal Resources and NABOR, we will make those changes as necessary. Go from there and work on best practices and do what we can to try to help everybody. I know it's a lot. I know the listing agreement and some of these other pieces, and also it's only my second time teaching these forms, so it's not as if we've taught these forms for the last 10 years and we know them, backwards and forwards. But we have spent a lot of time with them. So that's essentially, I think, my presentation. I guess I'm 5 minutes early. I don't know what that means, but in terms of where we're at, I mean, normally I'd take questions, but today we're not going to take questions. And that really sort of, I think, ends the presentation for the day. And please send questions off to Marty if you have them, and we'll do our best to try to answer them and to try to make it as easy a transition as possible with all these new changes.